Good afternoon and happy Law Day. I'm happy to welcome two of our Capitol Complex colleagues here to speak to us on a busy day of the session. They will be talking to us about separation of powers. Before I introduce our speakers, I want to make sure everyone knows that you can register downstairs for law-related giveaways, and you can test your knowledge on separation of powers with trivia. That will be available all day, so please stop by. So we have two speakers today. Matt Gehring is the staff coordinator and attorney in the House Research Department. He covers state government operations and finance, elections, and redistricting issues. He's also coordinator of the department's legal services team. Matt earned a law degree and a master's degree in public policy from the University of Minnesota. In 2016, Matt earned a Notable Document Award and a Legal Services Staff Achievement Award from the National Conference of State Legislatures for his work. Ben Weeks is a legislative analyst and an attorney in the House Research Department covering labor and employment issues. He also serves on the department's legal services team and is the House's lead counsel for employment and personnel matters. Matt is a graduate of University of Minnesota Law School. Prior to joining House Research, he was a clerk right here in this building for the Minnesota Supreme Court. Please help me welcome them.
Hello, everyone. As Liz said, I'm Matt from the House Research Department, and on behalf of both Ben and myself, we're happy to be here to celebrate Law Day with all of you. That's very exciting. It's a busy day across the street over in the state office building and the state capitol, but we're excited this worked out to have an hour here to have lunch with you and to also go downstairs and sign up for the raffle to win the CDs, which sounds very exciting. So the topic that we have today is separation of powers, and Ben and I have sort of lived separation of powers every single day in the work that we do for the House, and it's really one of these issues that I enjoy talking about and learning about, and one reason why I enjoy it is that there really are very few places in the practice of law where you get to really practice separation of powers law. And the two examples where you do get to practice separation of powers is the legislative branch, really, and the judicial branch. And I think that's sort of the case partly because I feel on behalf of both of our branches that we're kind of like the forgotten branch in state government. So everyone always feels, if you aren't particularly sophisticated with the law, you sort of assume that the executive branch as the biggest branch is kind of runs the show. We all know if you're an employee either here in this building or across the street that that's not always the case. So we'll just dive into some separation of powers law topics here. If you have questions as we go along, feel free to ask them. We'll get some questions from the webinar if they come up. Otherwise, we can save questions also till the end if you want to hold off.
Try it again.
There we go. So to start off with, if you feel like any CLE on separation of powers probably doesn't qualify for CLE credit unless you have some quote from the Federalist Papers or from a founding father. So this is the designated Federalist Papers quote. I'm not going to read it to you. I think all of us as attorneys at some point in our lives were able to write a really good essay either in law school or in undergrad or somewhere along the way where we could really parse the words of President Madison and really sort of dive into exactly what separation of powers means from a sort of academic and theoretical perspective. But that's not the frame we're going to take today. So the purpose of the CLE today is to really kind of talk about the practical impacts of separation of powers and how it affects our day-to-day work, both at the legislature and also here in the judicial branch. So to do that, we're going to start with what is actually my favorite quote about separation of powers, which is not this quote from President Madison, but is instead a quote from our Human Resources Director over at the House. This is a standard email that we all get, usually late in the fall, from Kelly Knight, our HR Director, who says, "Dear members and staff, this is to remind you that the House, the Senate, and joint legislative offices are separate from the executive branch regarding weather-related closings of state agencies and offices. The governor is the decision maker for the executive branch to close offices due to weather, and any decisions to delay the House of Representatives will be made by the Speaker of the House. The Senate Majority Leader will make decisions for the Senate offices." So we all get this email every year. We had to invoke it 2 times this year. And it's my favorite quote because really for legislative employees, when we wake up and there's a blizzard, as there was a couple of weeks ago, really all of us care about is not whether Summit Avenue has been plowed, but whether the speaker can get out his driveway out in Crown to get to work that day. So this, when Ben and I did this presentation before, we used this photo of this some people tobogganing on the Capitol Mall, and I won't tell you who we picked on at the time, but because I don't know this crowd exactly here, I'll just leave it ambiguous about whether you feel like these are legislative, executive branch, or judicial branch employees who are getting a snow day while everyone is back inside hard at work. But I also, we can sort of make light of these types of issues, but there also are very important principles that are at play here. And the reason why we have to be very careful about sort of who's calling the shots in each branch of government is really encapsulated by this quote that I included from a 1930 case, case from 1930 from the Minnesota Supreme Court, which provides that departments, provides that the three departments of state government, legislative, executive, and judicial branches are independent of each other. Neither department can control, coerce, or restrain the action or non-action of either of the others in the exercise of official powers or duties. And we see this principle being applied in lots of different ways. And as we go through, we're going to talk first about some kind of policy applications of how this principle applies, but then later on, when Ben comes up, we're going to talk more about how these principles apply in the context of funding state government. So the basic principle of separation of powers comes, as we all know, from Article 3 of the Minnesota Constitution. We have an express division of powers provision that provides that the powers of government are divided into three departments: legislative, executive, and judicial, and that no person or persons belonging to or constituting one of these departments may exercise any of the powers properly belonging to the other departments. This is the basic separation of powers principle we all kind of know and love, and we build off of this principle both in our case law and also in the way that we conduct our operations of the legislative branch, and I assume here in the courts as well. So let's take a look first at some, like I said, some sort of practical impacts of how separation of powers affects the work, particularly the work of the legislature. And we're going to start with a little tour that takes us back to 1971. This is an example of a case that we really could have a full hour CLE session if we wanted to on this 1971 legislative case. It's a redistricting case. There's lots of nuances. There's lots of political dynamics and interesting things going on. Because we only have an hour and we're not talking about this specifically today, I only get one slide on this topic. But the basic thrust of the case is this. In 1971, the legislature was involved in redistricting, as it does every decade. As also it does every decade, it seems to struggle with getting a set of district maps that the governor will agree with, and so the legislature in 71 was not able to get a new sub-district boundary signed into law, and so the case went to court. At the time, and this procedure has changed a little bit since then, at the time a challenge was filed not in state court, but in federal court now, so an assertion that the state legislative districts violated the one person, one vote standard that we all know from the Constitution and from Reynolds versus Sims, which at the time was a new principle of law. And as part of the court proceeding, none of the parties to the claim actually asked for a reduction in the size of the legislature. But as part of the process, the governor at the time filed a brief suggesting that one way you could redistrict boundaries was to reduce the number of legislators to, in the case of the Senate, to basically cut the Senate in half and then reduce the House from 135 members to 105. The court took this under advisement and decided that, yes, actually this was a great idea. They found some polling that suggested that Minnesotans agreed with this idea. They did some research into how districts might look and the benefits of the legislature that might accrue if there were fewer of them making decisions. And so it issued an order that not only directed new district boundaries, but directed this reduced legislative size. This case actually went up to appeal all the way to the U.S. Supreme Court. In 1972, the U.S. Supreme Court, in the case 67th Minnesota State Senate versus Beans, overturned the federal district court's decision and said that this was not a proper exercise of federal judicial power to reduce the size of the legislature to the extent that the court had done. And this is really, in many ways, this is really a federalism case. But the sort of roots where this come from is a separation of powers dispute between the executive branch and the governor, who suggested gee, I have a hard time dealing with the legislature. Wouldn't it be nice if there were fewer of them around? And the legislature saying, well, no, how about we keep the numbers exactly as they are? That seems great for us. And so that was really the dispute that ended up going on appeal and being resolved on a federalism claim. So that's one way in which separation of powers really impacts and can put legislative branches at risk, not just in Minnesota, but elsewhere, based on these types of disputes. The next sort of practical example we talk about is this map. I don't know if anyone in the room recognizes the photo of this hallway or the little green shaded portion of the map here. That's the second floor of the state capitol, right outside the Supreme Court chamber. I hope that no one does, except for perhaps Secretary Simon, who I see in the audience, because he used to be a House member. So this photo is a photo of House space in the state capitol. And the House has occupied this space since 1991, when the Supreme Court moved out of the space. But it was also the site in 1994 of a dispute between the governor and the House and the Senate over who had the right to occupy the space. And there's, again, a long story. We could do the whole hour on this grand saga of 1994. The gist of it is that in late December, December 21st of 1994, Governor Carlson at the time decided that he had the right to occupy this hallway in this office space in the state capitol, and directed that the House move out, and he gave 2 days notice. So he issued this order December 21st of 1994, and ordered that the House be out of the space by December 23rd of 1994, which is just before Christmas, to which the DFL House responded in kind, and I assume in a proper Bob Cratchit voice, said only the governor would feel the need to evict someone right before Christmas of the state capitol. This case went to the district court. The House, on its own accord, sought a TRO to prevent the governor from changing the locks on the doors on the state capitol and allowing the House to remain in place. The district court did grant the TRO and then ordered the parties to come to an agreement on their own. And you can sort of see, when you kind of read these documents, you can sort of see the judge kind of rolling her eyes about having to deal with this kind of dispute. But it is a dispute that really is a separation of powers dispute. It's a dispute about whether who gets to control space and who can occupy space, not just in the state capitol, but in other state buildings. And it's an example of a sort of arcane, weird thing that legislatures have to deal with, but does have a pretty big impact on how it conducts its business. I will say as a side note that eventually there was a resolution that included both the House and the Senate, as well as the governor, in allocating the space to the House, and then providing further renovation to the space in other parts of the building. But even to this day, I can tell you, and I can attest to this, that Capitol space issues remain aflame in other parts of the Capitol complex, and we'll just leave it at that. Our last sort of kind of policy application of separation of powers that I find interesting is a little bit more recent. This comes from 2012. And so everyone who's been around the Capitol for a fair amount of time probably will remember this. And we had 2 constitutional amendments in that year. And because of what I'm going to describe, I think I'm going to go full deep nonpartisan bureaucrat and describe the amendments. Amendment 1 as a constitutional amendment related to family law. And Amendment 2 is a constitutional amendment related to elections. And what we had at the time was a dispute between the Secretary of State and the Minnesota legislature about how those ballots should be titled when they were presented to the voters. And the legislature had a set of titles, you can see here on the slide. For the family law amendment, they refer to it as recognition of marriage solely between one man and one woman. And for the elections amendment, the legislature preferred photo identification required for voting. And then the Secretary of State, using statutory authority to provide titles, said instead that he would title the ballots as limiting the status of marriage to opposite sex couples, and changes to in-person and absentee voting and voter registration, provisional ballots. So we all, probably in this room, and people who are generally engaged with the political process, know what's going on here. We can kind of see the differences in the titles, and we also have a pretty keen sense of what these amendments probably do if we do some basic research. But the challenge that we always forget, especially when we're engaged in the practice of law, is that there's a good section of Minnesotans who don't necessarily engage in the way that we do. And so for many of them, the first time they might see these questions in the ballot would be with this title. and they'd have a basic sense of what the amendment is doing based on the tone of the title that's provided. On this slide, let's move back. You can see the way these ballots are formatted, and it's the shaded portion. So it's kind of the first thing that's highlighted when you go into vote. It tells you what you're looking at with the amendment. So there's a big issue between the Secretary of State and the legislature about how you would frame these amendments and how people would vote on them. So this case went to all the way up to the Minnesota Supreme Court. The court recognized the separation of powers challenge here. So the challenge is that we have the state law that gives the Secretary of State discretion to decide what a ballot title should be. We also know that the legislature under Article 9 has inherent authority to provide the format of ballots, to provide the way that a ballot is presented to the voters for purposes of ratifying a proposed amendment. So there's a clear kind of separation of powers problem here, where the legislature is effectively notwithstanding a statute that has been delegated to the Secretary of State to provide titles. And the court decided they didn't want to get into that. What they decided to do instead was to turn to this principle of avoidance, which is what we see often in separation of powers law, where the court decided to find a different construction that would allow them to get out of needing to really take a tough look at separation of powers law and instead find a construction of the statute that would allow for constitutional interpretation of the statute without, again, going deeper. So the court effectively punted here and said, we can find a construction here where the Secretary of State is allowed to provide a title for a ballot question, but only if the legislature doesn't otherwise provide one. And in this case, because the legislature did choose to provide a title, the discretion of the Secretary is more limited. So this is an example of a separation of powers case that I think is interesting, not just because of the way that the court handled it, but also it's a highlight of the fact that separation of powers disputes not only affect the legislative branch, and the judicial branch, and the executive branch, but we also often forget that constitutional officers have their own constitutional rights as separate constitutional offices under in state government. And so in this case, it was a dispute between the legislative branch and the Secretary of State. And we know that other constitutional offices, including most recently the state auditor, have been involved in litigation over the powers of their offices with respect to their constitutional duties as well. So this is it's an issue that always seems to be festering in one office or another, and does require occasional interpretation by the court. And next, so that's kind of the kind of highlights of the sort of policy-related separation of powers issues we deal with. The next section Ben's going to take on, and here's where we're going to talk a little bit more about the way that separation of powers impacts the way that we fund state government.
Hi, I'm Ben Weeks, and as Matt just said, we're going to shift for the rest of our presentation to talk about how one particular challenge that faces the state of Minnesota that implicates all three branches in a separation of powers area, and that is what happens when the governor and the legislature fail to enact a 2-year budget to fund the state government operations in Minnesota. And as I do when I talk about these things, I'm going to start with a kind of very base level discussion of how we do our budgeting process here in Minnesota. This is the 10,000 foot view. Minnesota passes 2-year budgets in every odd numbered years, generally speaking. And those budgets run for a fiscal biennium, which is July 1 of an odd number year through June 30th of the following odd number year. Now the Constitution, Minnesota's Constitution in the legislature section requires that the legislature adjourn each year, and it's an odd formulation, on or before the first Monday following the third Saturday in May. So usually this year it's May 21st. Sometime around the end of May, Matt and I get to go home, and we're happy, especially if we've passed a budget. The governor may call a special session thereafter. Only the legislature can adjourn a session, including a special session. And what we've begun to term this, when the governor and legislature fail to enact appropriations for any state program by that July 1st deadline, we generally term it now a state shutdown. And that just means that there is some agency, some operation of the state that normally operates that is unable to operate or has to operate in a limited way because they do not have appropriations for the work that they do. And this is all animated by another section of the Constitution. In the Appropriations and Finance article, Article 11, the first section says, no money shall be paid out of the treasury of this state except in pursuance of an appropriation by law. This is the legislature's power of the purse, and it's pretty short and to the point. Appropriation is the mechanism by which the legislature authorizes spending out of the state treasury. Without it, you can't spend. Or can you? Moving on to the 2011 state shutdown. And before I go into this slide, I'll just give a little background on what we've begun to term state shutdowns in Minnesota. This is a new development in Minnesota. If you graphed it, you'd basically have statehood, and then you'd have a flat line of 0. And then in 2001, it spikes way up, and we've had 3. But this is a new thing. So first, this came very close to happening in 2001, near the end of June, without budget bills passed or all budget bills passed. The AG for the first time, Attorney General for the first time, petitioned the Ramsey County District Court for temporary funding to continue operations of some state government agencies. This is the first time such a petition had been made. The court granted that petition, but it was mooted right under the wire when then Governor Ventura and the legislature enacted a budget on June 29th of 2001. In 2005, we had our first multi-day state shutdown. It was 9 days long, and again, the Attorney General petitioned the court to order something that has since been termed core funding. That order was in effect for 9 days until the governor and the legislature enacted essentially a truncated lights on type bill ordering temporary funding for agencies. And they then took several more days, but were able to agree on the remainder of the budget and was passed and signed. So that 9 days was enough time to kind of begin the legal proceedings, but the real effects of this thing had not yet been felt. And we didn't really learn that lesson until 2011, which was kind of the state's longest shutdown to date. And a little bit on the background of the 2011 shutdown, we have budget forecasts in Minnesota that come out in November and February that estimate how much revenue we're going to bring in and how much we're going to spend. In that February forecast, 2011, there's an anticipated deficit of about $5 billion. So the legislature and governor were going to have to come up with cuts, lower appropriations for a sizable chunk of the budget. At the end of the regular session in 2011, the legislature and governor had only passed one of our omnibus funding bills, and that's the omnibus agriculture bill, which tends to be relatively small and non-controversial and tends to pass first. They hadn't passed anything else. So the session had adjourned. In the middle of June, the Attorney General, acting in her parens patriae, kind of standing in for the people capacity, petitioned the Ramsey County District Court again for core funding for a number of agencies, most of the operations of the state. And on June 29th, then Chief Judge Gearing approved the petition and appointed a special master, who's former legislator and former Justice Kathleen Blatz, to determine core critical funding for state agencies. So this is an interesting animal that you can see the way it's happened. It's always been fast and furious. And in that 9 days in 2005, in the late June in 2011, what's really happening is a flurry of interested parties and a very busy and harried judge and special master. Everyone's arguing that their funding is important. They need to, they, unlike other agencies, need to have money because everything they do is crucial and has this implication and that implication. I have a binder in my office that's 5 inches thick. It's just the petitions that were made in the 2011 shutdown from every group, from the Minnesota Horsemen Benevolent Society to the agency that licensed barbers in the state. Nobody wants to be laid off. Everybody does important work and wants it to continue even absent a budget. But the judge is in a position to come up with some standards by which they're going to determine what is and isn't within their power to continue absent an appropriation. And they're facing that, Article 11, Section 1, very cut and dry. sentence that says, look, you can't do this with absent an appropriation. Of course, that has to give somewhere. We have regional treatment centers, inpatient treatment centers, correctional facilities, so prisons, nursing homes, veterans homes, that you can't just lock the doors on and walk away. Something has to happen. We have to figure it out. And that's left, in these cases, mostly in the first instance, to a Ramsey County District Court judge. So kind of the first time where these legal principles were put into law were in a June 29th order by Judge Guerin. And there's kind of two places where she teased out the principle for what could be funded absent an appropriation of law. And what's up on the screen right now is from her findings of fact in that order. And basically, so you've got 5 categories here. You've got basic custodial care for residents. People who are helpless and absent continued state operations are going to have danger to their health or safety. Other was broadly public safety and immediately public health concerns. That's things like we have emergency response departments in the state. The Department of Health coordinates responses to an outbreak of bird flu or something like that. Provision of benefit payments and medical services to individuals. I'll talk about that a little bit more detail in a minute. The fourth one was the preservation of the essential elements of the finance system of the government. That's less about health and safety and more about the practical reality that, if you're not, even without appropriations of law, we're still collecting taxes in the state. We don't need an appropriation of law to collect taxes, but you also need the numerous employees in the Minnesota Department of Revenue to actually do that work. And it seems foolhardy and difficult to just abandon tax collection, abandon accounting, banking, all the things we do that keep the state, kind of the money running through the state and tracked. So that was one of the things she determined was a critical core function. And then the final one was necessary supportive services, including but not limited to like computer system maintenance, internet security, and issuance of payments. And that's writ largely, that kind of covered physical and IT infrastructure of the state that we need to support just to be ready when we had appropriations to continue operating. So she kind of Judge Guerin espoused the legal principle in the conclusions of law section, and I'll just read it. She said core functions include matters relating to life, health, safety of Minnesota citizens, the protection of the rights of citizens under the Minnesota United States Constitution, and the maintenance and preservation of public property. And she looked to the federal government for guidance on that. Federal government had more experience with partial shutdowns, and to the point where their budget office had released a series of memos about how the federal government shuts down when it does shut down, and what stays running. She looked to that for guidance in addition to the Constitution and the laws of the state. There was a kind of a second principle that Judge Guerin looked to, other than kind of the inherent rights of Minnesota citizens, and that was something that hinged on contract law and the supremacy clause of the U.S. Constitution, and that was Minnesota. The reasoning went, Minnesota's entered in agreements to participate in state federal programs, most notably the food stamp program, temporary assistance for needy families, or TAMF, and Medicaid, which come with hundreds of millions of dollars in federal dollars administered through the state to engage these important social safety net programs. Looks like my slide got cut off there, but the basic argument was that it's the supremacy clause combined with the fact that we'd agreed to these things that keeps them running. An important thing in the background is we could forego these hundreds of millions of dollars in federal money if we stopped the relatively modest operations needed to continue those programs. So here are just some examples of things that were and weren't funded in 2011. Prisons, nursing homes, veteran homes stayed open. All federal state programs involving agreements between us and the United States government stayed open. The legislature and the courts stayed open, although I will note, and I think it's important to note, that because of the kind of special nature of the legislature in the budgeting process, the legislature is necessary to get out of this hole, right? The legislature had to pass a law in order to appropriate this money if the shutdown was ever going to stop. In some ways, the legislature kind of circumvented the courts here. Leaders of the legislature and their lawyers met with the governor's staff and people who ran the Department of Minnesota Management and Budget, and just kind of agreed that the governor's staff and the legislative staff would be funded. And we just kind of tell that to the courts and say, okay, you don't have to worry about this one. We're just paying this money out. We don't need an order. We're all good on the side. So that was never squarely decided by Judge Guerin in the 2011 case. Law enforcement personnel, state funded, school payments, which have statutory appropriations, state aids to cities, which have statutory appropriations, and benefit payments and medical services to individuals were all funded. So these kind of hinge on a number of different things. As I talked about, some of these fall under health, safety, welfare of Minnesota citizens. Some of these are animated by the Supremacy Clause of the U.S. Constitution, the fact that Minnesota has entered into agreements with the federal government to run some programs. And some of these are a bit more arbitrary. While the vast majority of Minnesota's operations are financed through these 2-year budget bills, which essentially say, you agency get X dollars to spend in fiscal year 2019 and fiscal year 2020, and then we're going to do it all again come 2021. Some, and somewhat arbitrarily, entities have what's called a statutory appropriation, which means written into law right there in the statute book, this agency is automatically appropriated all the dollars it collects in fees and things like that. So the appropriation is there and ongoing and never subject to this kind of shutdown scenario. And here's some things that didn't get funded: non-emergency road and bridge projects, kind of the most high profile one. And I think one of the things that ended up adding huge pressure to end the shutdown is that state parks were closed. People had people get those reservations months in advance and couldn't go out and go camping for no really good reason, not that expensive to run, but they just had to shutter the doors. They didn't have any staff. State licensing entities, the people who license cosmetologists, barbers, things like that, those were shut down. You couldn't renew your licenses, take examinations, things like that. And then a handful of state agencies, the Racing Commission, the Workers' Compensation Court of Appeals, and a handful of other random ones were shuttered for that time. And so here is what for some reason I fixated on as a kind of a microcosm of the issues in a state shutdown. So on your right there, those are wild Asian horses at the Minnesota Zoo. It looks like there's a little foal there too. And on the left are a couple of horses running at Canterbury Park. So as you remember, these shutdowns happen in July. July 1 is the first day. After that is what to many businesses, outdoor attractions, a very important weekend, July 4th weekend. And that's important both to Canterbury Park and to the Minnesota Zoo. Minnesota Zoo has said that they raise more revenue in that July 4th weekend than any other weekend of the year. And having to close during that weekend would be a huge blow. Same is true for Canterbury. And in particular, in 2011, behind the scenes, the Minnesota Horsemen's Benevolent Society, which I talked about a little bit before, had been going around the country talking up Minnesota racing and really working hard to bring thoroughbred racing to Minnesota and Canterbury Park in particular, and had a series of these races scheduled for July 4th weekend. So implications of the shutdown. The Minnesota Zoo, which had initially only been cleared for core funding sufficient to take care of the grounds and property and to feed and take care of the animals, repetitioned the special master and then Judge Guerin. And the judge found correctly that The Minnesota Zoo actually has a statutory appropriation by which all of the entrance fees you pay to get into the zoo, memberships, concession sales, souvenir sales, are automatically appropriated back to the zoo for their operations. So even though they sometimes get supplemental appropriations, they have an ongoing appropriation for most of their operating money. So the zoo was blessed to be open, and they were open on July 4th weekend. Canterbury Park is regulated by the Racing Commission. Absent those regulators having access to the park, it has to be closed down. And it was, and the Racing Commission's funding is passed, the Racing Commission's funding is passed every 2 years as part of a biennial budget. It hadn't been passed in 2011, so Canterbury Park was closed and they couldn't have those races in that July 4th weekend. And I believe the Horsemen's Benevolent Society was back at the legislature testifying on the two bills Matt's going to talk about. And this had real negative impact on them. They said, our reputation, we went around the country boosting Minnesota racing. We invited all these, I guess, high profile celebrity horses to come. They weren't able to do it. They just had to cancel at the last minute. And to hear them talk about it, they have not really recovered. And so that's just an example of some of the arbitrary results that come from shutdowns. A couple other quick facts on the 2011 shutdown. When it was all said and done, it lasted till July 20th, when the legislature and governor enacted all the remaining budget bills in a special session, so 20 days all in. 19,000 state employees were laid off or furloughed. About 12,000 were deemed essential and kept working. Before you think that state shutdowns are a useful austerity mechanism, according to the executive branch estimates after the fact, the state spent about 80% of what it would have been expected to spend, assuming a base level budget had been passed. So we're not saving the majority or even close to the majority of the money we'd otherwise spend. It costs money to shut the thing down. It costs money to start the thing up. And as I said, a lot of things are actually running. Because this was kind of the first protracted shutdown, we as a state kind of know how to do shutdowns now. It was the Attorney General's third time doing it. Ramsey County kind of had come up with a system for how to administer these things. Executive branch agencies knew how to petition. There are now furlough clauses negotiated into all executive branch collective bargaining agreements. They hadn't been before, so there's a mechanism to easily not lay off, not terminate, but not pay and not require come to work state workers. So we kind of thought we had it all figured out, but did we really? So moving on, the 2017 veto of legislative funding, I'm sure many of you in this room are familiar with this, but give a little bit of background. So on May 30th of 2017, just last year, after the legislature adjourned, Governor Dayton item vetoed the budgets of both the Senate and the House of Representatives. And you see those on the blown up box on the right there, subdivisions 2 and subdivisions 3. And in case you're curious, this is what that actually looks like. He drew through it with a marker. Looks like he used a ruler, signed his name, wrote the date. And then on the left there is an example of the constitutionally required letter that comes along with a veto message that comes along with a veto explaining why he did it. So then there was litigation. The legislature brought a lawsuit, the House and Senate together, alleging violation of separation of powers. And I'm not going to go into great detail on this litigation, not just because we lost, but because we don't have enough time. So that proceeded through the summer, including a district court order initially in favor of the legislature, which gave us some temporary money, and an expedited appeal to the Minnesota Supreme Court. November 16th of last year, 2017, coincidentally, the day Matt and I were scheduled to present the earlier permutation of this CLE, the Minnesota Supreme Court issued its opinion holding that Governor Dayton's item veto didn't violate the plain language of the Constitution and was not a separation of powers problem insofar as the legislature had sufficient reserve funding to operate into this legislative session. And then the court, citing deference to the political branches, declined to decide the issue of whether the veto was an unconstitutional attempt to coordinate the branch of government. So that was kind of the end of that. Turns out we did have enough money to make it into this legislative session because here we are. So very early this session, both the Senate and House unanimously passed a bill funding the legislature at vetoed levels plus restoration of our spent reserves, and the governor signed it. So it all ended with a bit of a whimper and a couple of hefty legal bills. But I think there's some stuff that came out of that litigation that has some important implications, both for separation of powers, but specifically separation of powers in the context of state shutdowns. In two places in particular, the court, and through the writing of Chief Justice Gilday, brought up brought up Article 11, Section 1, and talked about its power to order funding. First time was in an order, not an opinion, but an order on September 8th, 2017. And the order basically went through plain language textual analysis of Article 11, Section 1, and Chief Justice Gilday wrote, "We are unaware of any authority that allows the judicial branch to authorize spending simply because a party has asked a court to do so. In fact, our cases suggest that the judicial branch does not have the inherent power to appropriate money, period." And then it discussed more deference to the political branches, especially in the political process and the concept of judicial restraint. And then in the court's 6-0 opinion on the case, they again cited Article 11 of the Constitution and quoted some other cases. And I'll just read this quote quickly. So it says, "The language of Article 11, Section 1 of the Minnesota Constitution is unambiguous. No money shall be paid out of the treasury of this state except in pursuance of an appropriation by law. The purpose of this provision in Article 11 is to prevent the expenditure of the people's money without their consent, first had and given." And they cite a 1914 case. They continue, "In the face of this unambiguous language, we have declined to order funding, even in circumstances where constitutional rights were at stake." And the court went on to cite several cases, including one involving the provision of public defenders in criminal situations where the court had declined to draw the conclusion that an individual right under the Constitution also came with an implied right for the court to order funding absent an appropriation. So 6 justices, all still on the court, signed onto this opinion. Justice Strauss did not participate. I think this leaves, we didn't have clear law, and I think as Matt talked about before, as much as some of the discussion of separation of powers is kind of abstract and conceptual and highfalutin, it doesn't often result in a lot of appellate court guidance. These things don't tend to, you see the space case where it comes up, these things tend to get politically solved. The court exercises deference and restraint, so we don't end up with a lot of case law. So now what we're kind of left with in the, knock wood, it won't happen again, but seems like the result that in an odd year, the governor and legislature are unable to reach a budget deal. I think core funding is in more in doubt than it ever has been. And the way this will play out is absent a change in law, this will fall to a single Ramsey County District Court judge to determine. Traditionally, that's been the chief, but the chief decides who gets it. But you know, the chief has taken it on himself in recent years. But it's a really tough spot, right? Because you have these kind of, although dicta, these messages from the Minnesota Supreme Court saying pretty clearly, I think, we don't think we have the power to do this. And they're reading a pretty clear and direct sentence in the Minnesota Constitution that does seem to say, yeah, courts, you can't do this. But they're contending with at least the obvious cases is that what are we going to do with the prisons? What are we going to do with the veterans' homes? Like, do you make the decisions, let all the prisoners out or lock the doors and walk away? I don't think we do. I don't think we can. So all this is kind of a preface to say the next Ramsey County judge who this falls on is in a really tough spot. She's going to have to make some difficult determinations. You know, if anything, the guidance is in favor of just saying, no, I can't do this. And we'd have to see how that all plays out. But the legislature maybe has a solution, and I'm going to turn it back over to Matt to talk about a couple bills that have some ideas for kind of changing the default rules around these things.
Yeah, and before we jump into the legislative responses, I just want to highlight one issue that kind of Ben talked about a little bit, which is that some of these disputes really can create some sort of awkward bedfellows in the way that you interpret separation of powers and you apply it. So in the case of core funding with the legislative veto, one of the things that happened was that the legislature, in dealing with the request from the justices to brief on that issue, took the position that the legislature, that the court could not order core funding. So that was part of our brief. And it's a strange thing to be the branch that has been vetoed, and it's a strange thing to be leading the Speaker of the House, leading the House and telling your employees that, you know, we're doing what we can to keep you employed, but oh, by the way, we're going to go and tell the court that we don't think they should give us funding. And the reason for that claim is really a separation of powers claim, that if the legislature as a branch decides that, well, yeah, you know, the court across the street can start ordering appropriations, then that takes away legislative authority to enact laws that provide appropriations. And so, you know, in a sense, you know, Ben kind of said that the legislature lost in that case, and that was really the headline takeaway that many people got from the dispute. But really, at the end of the day, on this point related to core funding, the decision was a good one for the legislative branch, because while it remains ambiguous about whether courts would order core funding in the future, it seems to push in the direction of keeping that authority within the legislative branch and not within the judicial branch. So with all that, in the last 10 minutes or so, we're going to shift to the way the legislature has responded to the veto case. And I'm hoping as we do this, we can have a little discussion. If people have questions or thoughts, please feel free to shout them out or raise your hand, and we can engage in some back and forth. So one of the things that we know from these the shutdown cases is that the courts really want the political branches, the legislature and the executive branch, to work it out. And if we go back to the shutdown from 2005 that eventually went into litigation in 2007, we got a quote here that like expressly suggests in no uncertain terms that the legislature could work this out itself rather than having to come back to the court. So this is, as I said, is a Court of Appeals decision from 2007 where the court said, among other things, the legislature could prevent another judicially mandated disbursement of public funds without an authorized appropriation by, for example, creating an emergency fund to keep the government functioning during an impasse, or enacting a statute setting forth the procedures to be followed during a budgetary impasse. And in the 2011 shutdown case that Ben talked about, Judge Guerin in her decisions sort of suggested this again, that this would be the way to solve some of these problems, rather than asking a judge individually to make funding decisions on behalf of all state agencies. So there are two bills that have been heard in the House, at least this session, that try to address some of these issues. These are topics that are not specifically responses to the veto case, but they're more generalized bills that address all types of continuing funding issues. You do have, as part of your handouts, I think, in addition to the slides, there should be two bill drafts that you can follow along with. The first one I'm going to talk about is the draft that in the upper right-hand corner is labeled 18-5716. And this corresponds to what in the House is known as House Bill 3360. This is a bill of Representative Randy Jessup. And you can kind of see the basic parameters of what the bill does on the screen, and then on the handout you can see the actual words that would be in the proposed statute. Basically, Representative Jessup's proposal would provide for operating money for all branches of government through all direct appropriations at 90% of the level that it was funded at in the previous fiscal year. So effectively what that means is that we will have continuing funding, so we avoid a shutdown, except that inherently when we appropriate money without legislation and use the statute instead the agencies and branches of government would receive 90% of what they received in the previous fiscal year, so effectively a 10% cut going forward. And under this proposal, the appropriations at that amount would only last for the first fiscal year of the budget biennium, so it's the odd numbered fiscal year, and then after that we'd be back into the same position that we were before, which is not having a budget and having to go into court to either have an order for core funding or to have a political solution to the impasse. Yep.
So I have a question about the impact. One effect, obviously, is that it would continue appropriations. But the other effect is that it would potentially nullify an item veto or a general veto of an appropriation. Is that an unconstitutional infringement of the governor's veto power?
Right. So the question was, how does this bill draft potentially impact the right of the governor to item veto specific appropriation items? I'm not going to directly answer that question because the bill has not been enacted yet, and I think we would need to think about that more fully. But it is one consideration both in this bill and the next bill I'll talk about when we're looking at these approaches, we want to think about what is the impact on veto authority of the governor, what is the impact on appropriations power of the legislature, and are these appropriate policy decisions to be making, and are they consistent with constitutional requirements of law. I will say that this model, there are other states, in a couple slides, we're going to talk about some other state approaches that do follow hybrids of this model, and they haven't had litigation over item vetoes. And effectively what this would do is provide that I don't think it wouldn't overrule a particular item veto, because item vetoes are specific to programs or activities in a bill, and this is related to operating money for the operations of a full agency, and it's unlikely. Right, yeah, so this applies to both branches of government and individual agencies within each branch. So, you're right, so
you said this is been litigated in the other states?
No, yeah, so this is not, as far as I know, this is not, this exact approach has not been litigated in other states, but there are other states that have this model that have implemented it. So, yeah, I mean, I think the practical effect of this bill is that if the governor item vetoed the legislative branch, again, as he did in 2017, the legislature would invoke the statute and it would be funded at 90%. Rather than funded at 0%, as was the case last year. There are some variations that were included in the discussion of this draft when it was heard in the House. One of the things you can think about here is that this is a 90% funding mechanism, and what's trying to be accomplished with this draft and with the other drafts is to find a way to adjust the incentives of the legislative branch and the executive branch to really just come to an agreement and enact a budget. And so 90% was the number that was chosen for this draft as a sufficient enough cut that would have a severe impact on agencies in a way that people of all political ideologies would feel is too much and inappropriate. But there is certainly discussion of whether that number is the correct amount or not. And there are members that may feel like this is a pretty good deal. We could, instead of agreeing with the governor on spending items in a budget bill, we could just take this 10% cut and go home, and it's an across the board funding cut for the next year and be fine with that. So it's definitely a bill that it encourages that kind of discussion, and really, as we think about it from a separation of powers perspective, that's the kind of stuff that there are no clear answers to, and there's probably no right or wrong answer. This is the approach that Representative Jessup has put forward as his way of solving the problem, but it's not necessarily, and I think he would describe it as not necessarily a magic bullet that's going to prevent disputes in the future. So the next draft I'll talk about is the other one that's included in your handout. This is the one that in the upper right-hand corner is labeled H3891DE1. So if you don't understand our legislative coding, this is just referring to an amendment that was proposed in committee called the DE1 amendment for Representative Knobloch's bill. This approach is different than Representative Jessup's in that instead of funding all of state government at 90% of the base level from the prior year, this funds only critical functions of state government. In general, this means that critical functions in all branches, including judiciary and legislative branch, would be funded, but it requires some judgment calls by the Commissioner of Management and Budget on what constitutes a critical function and what doesn't. And if you look at the handout, you can see the specific detail about so sort of starting at the bottom of page 1 and then running through page 2 and 3, where the Representative Knobloch is trying to lay out some parameters for the Commissioner to use to decide whether funding is appropriate or not. And you can see that, for example, natural disasters and emergencies will be funded at the full amount necessary to respond to those things while the statute is in effect. But if you turn to page 2, what you see in subdivision 3 on page line 2.18, these functions that are listed under this subdivision would instead be funded only at the previous year's base level. So it's a complicated, this is sort of legislative speak for saying either you get last year's amount or you get the full amount that you need. And items that are the first in subdivision 2, you get the full amount you need, even if it's more than you spent last year. But starting with items listed in subdivision 3 and to the end of the bill, you only get what you spent last year, which might or might not be enough to fully fund the activities that you expect to operate in the years going forward. So this approach, like I said, is different in that we're only funding critical functions and not all functions, and there is some subjectivity to what that means. The appropriations, unlike Representative Jessup's bill, this law would stay in effect indefinitely until a new budget is enacted. So under the Jessup model, we would all come back in July 1st of the even year to argue again about enacting a state budget, and if we don't, we have a shutdown. In this case, we'd be preventing full shutdowns entirely by having this ongoing appropriation indefinitely into the future, except that you're only funding critical functions and not everything else. There was a version of this bill that I'll just kind of note in passing that originally delegated not to the Commissioner of Management and Budget to make these decisions, but instead delegated to the Supreme Court to apply these principles and direct funding accordingly. And I think that as Representative Knobloch worked through the sort of pros and cons of that approach, he decided that keeping the appropriations power within the executive branch rather than through a court process would be the preferable route. And I assume for those of you that work for the court, you probably would agree with that analysis. So there are a couple other states I mentioned in response to the question. There are a couple other states that do have continuing appropriation laws that apply and are in effect and that are used. So two that we highlight frequently are in Wisconsin and Rhode Island. So in both states, they have continuing appropriations laws that allow for base level funding to just continue indefinitely until something new is enacted. In Wisconsin, this law has been triggered fairly regularly, not all the time, but often enough that they kind of know how it works. The Wisconsin legislature has the authority to meet year-round and on occasion has waited until November or December of the fiscal year to enact a budget for that cycle. And this statute has been invoked to allow for funding, even though their fiscal year begins in July, they're funded through whenever the legislature enacts a budget based on these prior years levels. Rhode Island has a similar process. The difference in Rhode Island is that for whatever reason, the culture in Rhode Island is that they always agree in a budget and have never actually had to enact or invoke their continuing appropriations law in the way that Wisconsin has. And then finally, just in the last couple of minutes, I'll just kind of highlight that the federal government also, as we all know, occasionally struggles with appropriations. And so they take a different approach. These approaches are not really an apples to apples comparison with the way that we budget in Minnesota. But I'll just note that we all heard the term of sequestration and fiscal cliffs and debt ceilings and all these other things that Congress comes up with as a way to provide funding for the federal government. They're all really sort of variations on this same theme of trying to find a way to balance the powers and duties of Congress to enact appropriations for the federal government and to avoid government shutdowns, and also to preserve kind of these traditional principles of separation of powers between the legislative and executive branch at the federal level. And we can all, as we're eating lunch or going downstairs to sign for the drawing, we can use among ourselves about whether these approaches are successful or not at the federal level, but certainly they reflect, as I said, these efforts to address some of the issues that we're dealing with here in Minnesota in a little bit different way. If you have questions or would like more information, I'll get to Bert in just a second. We have on this last slide here a link to one of our House Research colleagues, Colby Sullivan, wrote a really good piece on automatic continuing appropriations and government shutdowns, and has lots of history and examples of other proposals that have been suggested in the past to deal with these types of issues. And you can find that publication at the link on the screen.
Now, before we describe the judicial approach, I just want to point out that on page 28 of the Supreme Court's opinion, they say, our decision today should not be read to foreclose the possibility of a judicial remedy in a different situation. As we state in our order of September 8, 2017, Minnesotans have a constitutional right to free and independent branches of government, each functioning at a level sufficient to allow the exercise of constitutional powers to each branch for the security, benefit, and protection of the people in whom all political power is inherited. So I think we've left the door slightly ajar, maybe more than slightly ajar.
Yeah. So the suggestion was that the court's opinion in the veto case related to the legislature kept the door open to the possibility of court funding in the future. I think that's right. I think what we learned from that case is not that the court will never agree to order court funding, and even in the case of the legislature, if the circumstances were different and we didn't have a budget reserve available, they might have analyzed the situation differently. But what we do know from that case is just that the court is clearly expressing its skepticism about this process and is suggesting that in the future they're going to really take a closer look at whether this authority exists or not and whether there are other remedies available, because presumably from their perspective they would prefer not to have to be making these individual decisions like Ben mentioned about which horses get fed and which ones don't, and so it remains an ambiguous area of the law, I would say. Anybody else?
In 2011, the first time where the judge was saying these are core functions and should get funding. Did anyone raise any objections to the idea that the judge was holding funding? Because I assume that the executive and legislature both want the funding. They're not going to object to it. But did anyone else raise an objection to that?
I'll let Ben answer.
I do recall some Amici and things that were raising those specific objections to that type of funding. Of course, the vast majority of petitioners to the special master in the court were looking for their funding, and that won out. And again, it's that same, I don't think a judge facing this stuff, it would be really hard to draw a hard line. The question is, how squishy do you make the line? I think most of the time, you got some of the kind of very obvious areas where we're just not gonna shutter the doors of, assisted living facilities, things like that. Yeah. So I think those arguments were in there. I remember one or two. Anybody else? And you guys feel free to leave. We'll stick around and answer questions for a little while for those.